Do you see it? Okay, just like I said in the beginning, I don't think everyone was online. I'm using TerraLex template for that. Thank you, Nicole, again. Well, thank you guys for taking part in this event. It's my pleasure. The invitation was very good. Just like Rob mentioned, we took part in some presentations for ACC, and we have been talking about compliance matters in the Americas and anti-corruptions and anti-money laundering. And then Rob and Nicole came up with the invite for me. And as I mentioned, it's my pleasure. I will move on with the slides. So if I have any difficulties, I'll let you know, okay? Well, first of all, I think it's important, before going to anti-corruption and everything else, I think it's very important for us in TerraLex and us as legal professionals understand a little bit what has been going on in Brazil for the past 20 years. We had a left-wing government from 2003, 2006 with Lula da Silva, then shifted, to Dilma Rousseff, who was also appointed, let's say, indicated, suggested, created by Lula da Silva. Then she was impeached in 2016. And then we had Michel Temer, who had this, let's say, rest of the term to finalize as president. He was the vice president of Dilma Rousseff, sorry, not Dilma da Silva. And then in 2018, we had the election of Bolsonaro, who was a very, very right-wing politician. He was very into some agendas for right-wings. He had some, let's say, different. He had very different perspectives from Brazilian point of view related to politics. He had a very good ideas in the economy. Of course, we have in Brazil some difficulties regarding our Congress. It has been changed during the past 20 years a lot. So today we have Lula da Silva again re-elected in 2022, and he will have his mandate until 2026. Okay, this is a very quick overview on what we understand, of course, as ways to work and like a photograph of left-wing and right-wing jurisdictions here in Brazil and politics here in Brazil. Of course, it's basically the same all around the world, but we just wanted to show a little bit on what's important from each kind of drive from politics. Of course, Lula da Silva is from the Workers' Party. He is much more worried with social issues, with inclusion issues, with environmental issues. So he has, since last year when he was in campaign, he was selling the idea of including these material problems in the agenda if he was elected. On the other hand, we had Jair Bolsonaro from the Liberal Party, which, as I mentioned, he came to power, he became president because, I will say that in the next slides, but he became president because of Operação Lava Jato, because of Operação Car Wash. Why? Because during Operation Car Wash, what was found related to the Labour Party, Workers' Party, PT, was that during their time in Brasilia, they were involved in several problems. Let's say we had Odebrecht, we had other construction companies here in Brazil, all of them involved in problems, in corruption issues. And then Operação Lava Jato came up, and of course, it's one of the most famous compliance operations, let's say, involving all types of authorities in a country, and it happened in Brazil. it was very well, let's say, rated. Yes, it was very well qualified by the population until Operação Lava Jato, I mean, until there was some leak of conversations between the judge, Sérgio Moro, and the Federal Prosecutor's Office, Deltan Dallagnol, and others. And it came as a bomb for Operation Lava Jato, for Operation Car Wash. It took out a lot of credibility from the operation. And of course, it came to the Brazilian politics as a, like, let's say, waiver for Lula da Silva to run again as a candidate for the elections in 2022. With his election, this is just our stock exchange overview since February 2023. I mean, what happened in October, we had a small variation from the shares negotiated by public companies. In December, we had a little bit going down. And then in February, we just kept on the same way since October 22. We had a decrease of approximately 3.48% in those 6 months. What does it mean? It means that Brazilian economy is strong. We have very strong authorities here in Brazil because due to Operation Car Wash, there were changes in the Brazilian regulation regarding corruption and anti-money laundering and any other kind of compliance matters that may take part with public authorities. Of course, if you have a left-wing government, the main focus will be in social programs, employment, public investment, and the state presence in the economy. On the other hand, you have the fiscal responsibility and the inflation. We just wanted to point out in this drawing to show everyone what are, of course, the worries that we may face in Brazil for the next 4 years, because whenever we have, of course, an increase in public investments and public development and state presence in the economy, there's a risk, of course, of having inflation and generating some kind of fiscal responsibility. This is it needs to be very understood by the population. Okay. This was a general overview on Brazilian politics for the past years for you guys to understand a little bit where we are. It's important to show to the world, let's say, how things are done in Brazil. We have drafted a few slides on anti-corruption law, anti-money laundering, and other things that we understand that are interesting for you guys to take a look at, to understand a little bit. And in the end, we are going to present a I think 4 slides from case Americanas case. This is huge, something like $40 billion bankruptcy that's going on here in Brazil right now. There's a fraud that's being discussed. It's not proven. It's not demonstrated. There's no material evidence that it has in fact occurred, but the market says that there's a possibility of fraud happening. Okay, so let's move on with the new regulation of our anti-corruption law. Last year in 2022, we had the new decree for the anti-corruption law. We had the previous decree was from 2015. So just like I mentioned from Operation Car Wash, it started around 2013. 14 came 12 and 14 came to the public with power. Everybody was clapping to Operation Lava Jato, and everybody was very happy what was going on. And then the law, the anti-corruption law, the Brazilian anti-corruption law, is from 2013, in fact. And then the previous decree regulating the anti-corruption law was from 2015. And 2022, the government came up with a new decree that's very important for the development of the market, of course, after 7 years of the previous decree. It came with a few changes that may be considered relevant for our clients and for our operations as lawyers in Brazil. If you have clients in Brazil, if you have clients related with Brazilian companies, it's important to understand the Brazilian regulation and compliance, because it may impact the business that's being made. Of course, Brazilian regulations, I mean, the decree and also our anti-corruption law derives very much from other regulations around the world, especially from the FCPA in the US and the UK Bribery Act and in the UK. So we do have very similar concepts in our anti-corruption regulation, but of course, we do have to adequate the compliance material from our clients to Brazilian regulation. This is something very common that we face. We have a lot of international clients. They come to Brazil and say, okay, I have a compliance program in India, for instance, or in the UK or in the US, and I'm going only to translate the material that I have, I mean, the codes and procedures and everything else, and then they're going to be sufficient for Brazilian regulation. No, they won't. This is a no answer, because we do have a specific regulation and everything needs to be done in accordance with Brazilian law. Whenever, even though you have it abroad, if you're part of any kind of procedure, sanctionatory, administrative, whatever, criminal, if you don't have a compliance structure in Brazil in accordance with Brazilian law, this is going to be a problem. Okay, this is very important for us to highlight, because whenever we have clients that come here and say, no, you're Brazil, everything is going to be fine. No, if you don't have, it's going to be a problem for you. Okay. I'm going to walk through the slides and show you a few notes that we have made, because otherwise reading the slides is a little boring sometimes, and just go over it so that you can take a look. And of course, feel free to ask me any questions regarding the slides, and it's good, in fact, to have it questions, because it may create additional interest from the discussion. Okay. What was the, let's say, main changes? What were the main changes for the new decree? We have a new structure for leniency agreements, and of course, they have included additional criteria for compliance programs. They have included, let's say, more clear risk-based approach on the compliance that needs to be taken. Leniency agreements in Brazil were, when they started to be made after the anti-corruption law, and especially due to Operation Car Wash, they were very confusing, let's say. Why? There were actually at least three governmental authorities that were trying to be responsible for that. The General Prosecutor Office, the General Controller's Office, and of course, the Congress itself. Everybody was trying to have the, let's say, the say in the leniency agreements, and trying to make it appear as if the celebration of the leniency agreement was something that such authorities would be responsible for. What it has created in the market. Insecurity. When the big construction companies were involved in the leniency agreement, there was a very reasonable doubt, let's say, that celebrating a leniency agreement with one specific authority may be challenged by other specific authorities. During the first years of Operation Car Wash, and until 2017, 18, something like that, when Braskem took their first leniency agreements, there was a confusion on which kind of which government authority would be responsible for taking care, let's say, of the leniency agreement. After that, I'll show in another slide. There has been some development on that. Now it's much simpler to identify which authority, which government authority is responsible for that leniency agreement? Who is the person in charge? How do we negotiate with the authorities to celebrate a leniency agreement? The procedures, the amounts, everything is much more clear than it was before the decree of 2022. Okay. Sorry, something came up to my eye. Just a second. What we have seen in the compliance issues, the compliance matters, programs that need to be improved. This kind of harassment, anti-fraud, money laundering, terrorist financing, and compliance, tax and digital. Whenever we started to speak about compliance in Brazil, or when we started to speak about compliance in Brazil, the compliance manuals were very standard. Everybody used it to go to the internet, or you hire some specific service provider and say, okay, this is a lawyer who's going to create a manual for compliance for my firm, and I'm going to sell it for 100 different other firms and use it as, let's say, a standard compliance manual and procedure. Of course, what happened, what was being identified by the authorities was that if you have a compliance structure that's just on paper, it's just for you to deliver the information to the authorities if it needed, if it requested. And of course, this compliance program does not take place effectively. You don't have budget for that, you don't have people for that, you don't have evidence that you have training for all your employees, for instance, and everything else. If you have this kind of structure, let's say, not a fake structure, I would say, but if you just have the paper with written information, the authorities would, let's say, give you some kind of specific sanction. Now, what happened was, with the new decree, there has been a specific regulation saying that whenever you have this kind of structure, if you have a structure for just in the paper without implementing, in fact, the compliance structure in your companies, this is going to be, you have a more severe sanction whenever you have a administrative procedure regarding compliance matters. So the new decree came to give some light on some things that were being discussed in the market for the past years, but were not, in fact, duly regulated. Okay. One thing that's very important: risk-based approach. I'm a partner in Motta Fernandes for compliance and capital markets. So this is something that we have been seeing a lot with the companies listed in our stock exchanges and publicly traded, meaning even with shares or debentures or any kind of security that's being sold. Whenever we have a service provider in capital markets, for instance, that is taking part in the issuance of debt or credit or whatever, and this specific service provider does not have risk-based approaches. I mean, this is for the Securities and Exchange Commission, okay? Doesn't have a risk-based approach, evaluation of their compliance risks, and of course, the risk-based approach that they have, this is going to be a problem for them. So the new decree came to clarify the needs for the requests for certain regulation. What does it mean? Sometimes here in Brazil, but I don't know if the other jurisdictions, if you have the same problems that we have, but sometimes we do have. People just create regulation and laws, say, oh, this is the law, just follow. With this compliance regulations that came up during the past years, it was very important for the market, from the companies involved, to better understand the reason why they were existing. Why is that? Why do I have why do I need to have a compliance structure? Why do I need to have compliance officer? Why do I need to invest $1, $2, $5, $10 million a year to compliance structures? This was something that needs to be explained to the market. said to the market. Otherwise, people were not going to follow. Of course, if you have a sanction against any kind of misconduct, this is going to be also a very good idea to follow. One important thing that happened last year that I think it's good for just give an overview here, quickly overview. Crypto assets in Brazil have been exploding regarding the amounts that are being deposited, the kind of transactions that are being taking place, who in Brazil will be responsible to regulate the Securities and Exchange Commission, the Brazilian Central Bank, how it's going to be deposited, registered, how it's going to be registered with your federal revenue, everything else. I mean, it was very important for the past year to understand specifically what's the relevance of regulating crypto assets in Brazil. It was all the digital assets had been, let's say, treated during the year of 2022, specifically those by the Brazilian Central Banks and the Securities and Exchange Commission. Crypto assets here now are regulated, they exist. There's the possibility for investment funds, for instance, to invest in crypto assets. It's regulated and it's authorized. It was not before, but it's now. I mean, whenever you can, if it's a foreign investor, it can come to Brazil and invest in a fund that invests in his portfolios in crypto assets. It was not possible before, but now with the changes, it is possible. Of course, there are several discussions on the underlying assets of the crypto assets, if it's good, if it's bad. I mean, this is not something that needs to be discussed in this forum. It's something just like an option to invest or no. It creates money, it creates benefits for the owner of the credit. I mean, it's not underlined in anything, in any company or whatever, but this is a kind of an investment. What I included here was anti-money laundering requirement for crypto assets specifically that is interesting to better understand how Brazilian Congress and Brazilian regulation has been treating this anti-money laundering specifically. The VASPs, the virtual asset service providers, they have been also regulated, so they can provide services, they can sell assets, they can work in the capital markets, that's okay, but they will be regulated in a very strong way. Meaning, of course, it will need to have all of those compliance manuals, it will need to have all of those investments and budgets to be allowed to operate in the crypto market. Okay, this is just an overview on that. Anti-money laundering and related regulation. What have I done here? I think it's good to clarify that during the past 10 years, after actually the Operation Car Wash, several changes came up through the anti-money laundering regulations and everything that's linked to this kind of crime or conduct or misconduct. I have drafted a few questions with three slides actually that are interesting for you guys to take a look to better understand the money laundering regulation here in Brazil. The base for money laundering regulation is that we can have a administrative misconduct regulated specifically, for instance, by the Brazilian Central Bank or by the Securities and Exchange Commission. And of course, we can have the other side of the coin, that's the criminal problem. They're both sanctions applicable to issues related to anti-money laundering situations. Specifically my area, capital markets and regulatory, we have seen several clients involved in problems due to anti-money laundering. What we have faced, I was having this discussion with Fernando Stacchini, that you guys know very well from TerraLex. There's a client asking for, let's say, a little bit more understandings on anti-money laundering situations for regulated financial institutions. We have several clients in these areas, of course, and then what I have explained to Fernando is that the Brazilian central bank now understands very well that they are very powerful. They do have information regarding to everyone that comes to Brazil to invest. I mean, foreign investors, Brazilian investors also. So there's interchange of information between all authorities, meaning central bank and the Securities and Exchange Commission and other authorities, to exchange information on the market and on the investors. So nowadays it's very complicated for anyone to operate in a Brazilian market without seeking all of the anti-money laundering regulations that we have. What's the main worry of our clients? Oh, if I'm sanctioned, what are the sanctions? How can I solve the problem? What can happen to me? It depends. It depends on which kind of violation we are going to discuss. It depends on which authority is responsible for applying such sanction. Is that the central bank? If it's the central bank, it goes up to 2 billion reais. It's something like $400 million, depending, of course, on the kind of sanction, the amount, etc. This is not the standard, of course. But it needs to be understood that the amounts involved in financially speaking, the amounts involved in fines in Brazil today regarding anti-money laundering and the lack of compliance with these regulations is huge. Whenever you come to Brazil, whenever our clients here operate, we need to be very clear on that. We need to have controls. We need to have systems. The discussion I was having with Fernando yesterday was, if you have a client that's planning to get into the regulated market of financial institutions, for instance, tell him or tell her or tell the client that they need very much to invest, and they need to have a very strong system to control the investors, to have a know your client procedure very deep and performed, to have controlling systems of anti-money laundering to avoid this kind of situation. Otherwise, you're going to be otherwise the client is going to be very, let's say, it's going to be a very problematic situation for the client. So this is something that needs to be very that needs to be understood whenever you have to work with Brazilian client, with Brazilian regulation on anti-money laundering. I'm just going over here and moving on with the slides, give you some time to read, because I'm not reading everything. I'm just saying and trying to see if you have any other questions, okay? What we have been facing also, our regulatory authority here is the COAF, the financial authority here in Brazil is called COAF. There are several, let's say, procedures internally in COAF also regarding money laundering. So whenever you operate in Brazil, or whenever you have investments in Brazil, or whenever you have business in Brazil, you need to communicate with the COAF to provide those reports periodically speaking. Say, okay, I did not have any situation of potentially harmful to anti-money laundering regulations and everything else. COAF is very involved in the Brazilian regulatory system. So as I mentioned, they have interchangeable information between all of those authorities that deal with the market, and of course with the regulatory issues like the central bank and other institutions. We have faced it in Brazil during the past 4 years, let's say, a scrutiny in financial institutions because, of course, one of the reasons, of course, was money laundering. We have several fintechs coming up. We have several, of course, due to this kind of, let's say, liberalization of businesses, we have several Ponzi schemes coming up in Brazil. It's very, very common today. We have understood that sometimes liberating the market to operate by itself may create some difficulties for the market as a whole. may have players that do not work properly. We may have players that try to manipulate, and of course, this is going to create a inconsistency in the market, and for everyone, for the economy, for the market, for the government, any kind of inconsistencies in the market is bad. So this is something that happened during the past years, and one of the reasons that COAF and other authorities decided to have a more strong interaction with the parties and with the business people is that the anti-money laundering situations should need to be very detailed and controlled. Okay. This is just a overview on which authorities are responsible for anti-money laundering situations. I'll share with you guys these slides after, don't worry, for you to have this guide. It's good for you to have this guide to understand a little bit more on the anti-money laundering situations, okay? I'll go to, let's just step those because, skip those actually, because I have just said a lot about it and my time is moving. The public bidding law we had in 2021, we used to have a law from 1993. So you can imagine, I'm not sure whether you have in your jurisdictions laws that have been in place without any changes for 30 years. Yes, 30 years or almost 30 years. Here in Brazil, a law that's not been changed in 30 years, it's difficult. Usually we have lots of updates on those laws and everything else. So for public bidding law, this is important for clients that are interested in taking part in biddings. We have clients, of course, foreign clients that are very interested in investing in Brazil. Of course, because of the exchange rate nowadays, Brazilian real lost value related to US dollars or to euro or to other currencies around the world. So for some clients, it's interesting. It's an interesting moment to go to Brazil, to invest in Brazil because of the currency itself. Of course, if you want to take part in public biddings, you have to follow this specific regulation, and this specific regulation is very strong on compliance matters. So before coming to Brazil, before deciding investing in Brazil, it's important to have this kind of program in place, okay? What I was mentioning before, the General Controller's Office confusion on authorities regarding the celebration of leniency agreements. What this new decree of 2023 came up to put some clarity on that and to try to show the market how does it work, which steps need to be taken. It was very well received by the players in this market specifically because it gave safe or it gave sufficient security, let's say, in a way that it's now much more reasonable to celebrate or to discuss a leniency agreement with a specific authority without having the risk of being involved in another discussion with another authority, and they don't share information between themselves. So with this new decree, it came this new regulation for the leniency agreements. It's interesting. It's important for the market in the Brazilian. On the Brazilian perspective, it gave us players much more tranquility to go over any negotiation in leniency agreements. Okay, I just want to go over, just like I mentioned, the Americanas case. I'm not sure if everyone is involved or took part or read about it. I'm not sure how many information you have reached regarding the Americanas case, but what happens is we have some big investors here in Brazil that it's three big investors here in Brazil, persons specifically. They are in the market for the past 50 years, investing in companies and everything else. They have investment in several other big companies, and one of those big companies is Lojas Americanas. That's a retail store here in Brazil, used to be very big. And then they gave like a shift in the kind of operation they had, and they somehow became a marketplace for internet. So they have small shops now, physical small shops, and the big, let's say, the big deal for them is marketplace and a digital e-commerce. Okay. They have drafted their financial reports for the past 10 years or something, 8 years, without identifying some specific accounts. And in the beginning of 2023, there was a new CEO appointed. And then the new CEO in something like 5 days, or it's a little odd, let's say, but something like in 5 days, he came up in a meeting and said to the board and said, okay, I do have problems here with this specific account. I would like to clarify it a little bit. And then he came up with the information that maybe there was an inconsistency in their accountability from Lojas Americanas that could take up to 20 billion reais. It's something like 4 billion US dollars, 5 billion US dollars. It's a lot of money. Dependently on which country you are, 4 to 5 billion US dollars, it's a lot of money. Our Securities and Exchange Commission began to investigate, to try to understand what was going on, because they are publicly traded. So they lost, just like mentioned before, 77.3% of their share value within 1 day. So the market just like, fell crazily that day. Everyone was involved with Lojas Americanas. They are very big. As I mentioned, they are a marketplace today. So they have lots of suppliers, lots of clients. It's huge. So any kind of problem with their structure would, of course, impact the market as a whole. So what they found in this specific case was that this accounting, these registries, certain registries of their financial statements may not include some debts that they have with the suppliers. So that's for a fate situation. One thing that was very interesting in this Americanas case was that the big auditing companies that were involved are PwC and KPMG. And they are being, of course, everyone is being sued and discussed and called and everything else to say, okay, how did it happen? I mean, it's not a fraud of, it's not a small fraud. It's a huge fraud. As I mentioned, in any currency you consider, 5 billion US dollars is a lot of money. And I mean, this was the fraud identified in the beginning. After the bankruptcy that they have filed for, they have identified with all the creditors and everything else, the total amount of the problem is approximately 43 billion reais. It would be like 9 billion US dollars. It's a lot of money again. So when we have independent audits going after their responsibility, or the Securities and Exchange Commission going after responsibilities for the gatekeepers of the market, it comes up with a very important, let's say, mindset changing to everyone that works with this kind of transaction. I mean, the role for gatekeepers, for instance, is going to be much more appreciated, let's say, much more important whenever you have to deliver your financial statements. There has not been any kind of culpability defined up to this moment. The other slides will show you the amount of regulatory from the Securities and Exchange Commission, the amount of regulatory proceedings filed against Americanas and the other parties involved. So this is nowadays, on the present date, the case of Lojas Americanas is the big compliance problem that Brazil is facing on the market regarding this kind of transactions and this regarding fraud specifically. Okay, from my perspective, this was the idea, just to give you guys an overview on the Brazilian regulation and what's been going on in here. And of course, as I mentioned, I showed you some points that I consider interesting for development, for going on with further discussions if necessary, because Brazil is I don't know if it's good to say that, but Brazil is, let's say, a very good environment for developments and compliance issues, because in other countries, you guys have, the regulation has been there for 20 years, 30 years or something, it works and everything else. But here in Brazil, we do have some room to discuss things. So of course we have misconduct, we have problems, we have issues, and then we come up with a regulation that's very useful for the Brazilian market. And sometimes it's also useful to other jurisdictions. So I mean, if I need to put some more information or more color on this presentation for you guys, or if you need me to provide some other information, it's my pleasure. Okay. So thank you very much. Thank you, Nicole and Rob, for the invitation again. And this was my idea with you guys.
Great. Thank you so much, Guilherme.